哋夠鐘有個人準備開會，而家開會啦。
Yes, please take a seat. The meeting is now called to order. Please invite officials in.
我哋起碼要幾多啊？3個啊？4個？4個。啱夠咁走晒，你唔好走啊！哇！唔好走啊！走剩翻我同局長兩個，即係局長噏兩句就散會㗎啦，我哋。今日會議呢就唔係好複雜。
Today's meeting is not too complicated. Maybe we can leave earlier. Agenda item number 1. Confirmation of minutes of the meeting held on the 17th of March. The minutes have been sent to members. Secretary has not received any proposed amendment. So the minutes are okay. Item 2. Information papers issued since the last meeting. The administration has provided 2 papers. The first one, information on financial position of the Applied Research Fund for the period from the 1st of September to the 30th of November 2014. Paper CB1 794 1415 bracket 01. The second paper is the Legislative Council briefs on United Nations sanctions, Central African Republic Regulation 2015 and United Nations Sanctions Democratic Republic of the Congo Regulation 2015. Paper CR 75 53 8 and CITB CR 75 53 4. Date of next meeting and items for discussion. Our regular meeting in June is the 16th of June at 2:30 p.m. The first item is increase in the commitment enhancement measures for SME Development Fund, SME Export Marketing Fund, and number 2, Progress Report on Research and Development Centers 2014-2015. So there are 2 items for discussion at the next meeting, which is on the 16th of June at 2:30 p.m. Item 3. Progress of the working group on intellectual property trading. May I welcome Mr. Greg So and his team. Let's be brief and concise. I invite the administration to introduce the paper, and then members may ask questions. Mr. So, please. Thank you, Chairman. At the 20th of May meeting last year, we reported to members the work in progress of the working group, and we now report to you or update you on the work of the working group in the past year. In 2014, the working group, according to the plan and strategy, looked into suitable policy and supportive measures to promote IP trade in Hong Kong. The working group has completed its work, and on the 23rd of March, the working group issued this paper and made 28 recommendations and positioned Hong Kong as the IP hub trading center, IP trading hub in Hong Kong, in Asia. And the administration has accepted the recommendations, and let me highlight the details. There are 4 strategic areas. Strategic Area 1, enhancing the IP protection regime. Strategic Area 2, supporting IP creation and exploitation. Number 3, fostering IP intermediary services and manpower capacity. And number 4, pursuing promotion, education, external collaboration efforts. The 4 areas have been explained in detail. Maybe I'll leave some time for answering members' questions. Mr. Jeffrey Lam. Thank you, Mr. Greg So. We have seen in recent years that the mainland has rapid economic growth, and this has led to the demand for services in respect of IP trading. And the demand for such service is getting stronger and stronger. Hong Kong has its own judicial system and also has its own IP system. There are a lot of opportunities arising from IP trading. As for those involved in IT, they said that in IP trading there were quite a lot of disputes. In Hong Kong, the arbitrators who are familiar with IP are not too many. If the administration wants to turn Hong Kong into an IP trading hub, apart from providing hardware and government support, there is also the need to provide software. Dispute resolution is necessary, and there is a need to provide manpower for that purpose. In terms of dealing with IP trading disputes, would the administration consider augmenting the manpower, providing more training, and what's the progress so far? That may have implications for other government departments. So in terms of coordination, what has the administration done? Thank you, Mr. Lam. For your question, Mr. Lam is right with regard to encouraging IP trading. We need to enhance our intermediary service and enhance our manpower. We need experts of different areas. There is a due process list formulated in due diligence list. The IPD has worked with the Law Society to produce such a list, and it's also very costly to comply with due diligence. If more people understand the process and details, then that may help to cut cost. If businesses have a better understanding of IP trading and understand the procedures and effectiveness, then the IP due diligence list is very important. As said by Mr. Lam, with the rapid growth of IP, there is a higher chance of disputes arising from IP trading. Apart from litigation, arbitration, and mediation are also available, and they are less costly, and they are more, they call a shorter period of time. And we are working with the legal professional to promote the resolution of disputes through and they are going to launch the IP management and IP manager scheme, and the IPD will sponsor this and provide relevant sponsor and promote the training courses to facilitate the development of IP-related services among professionals and nurture talents. Mr. Jeffrey Lam, I agree with the Secretary with regard to the efforts they've made, and I think they should speed up the pace. We cannot just call ourselves a hub, and then we go to find the bodies. And if we can't train, we don't have enough talents, then we should attract more talents to come to Hong Kong so as to assist our development in this area. Mrs. So, I also have some questions. In respect of paragraph 8 of the paper, in the past 6 months, the administration has provided free IP consultation service for SMEs. How many SMEs have called for such help or have sought such consultation service? And what are the major areas of consultation? And will this service be regularized? It is just a pilot scheme now. Now it said that the administration will consider the feasibility of formally launching the service. So will that be a permanent service? If I may ask the Director to answer. the question. Chairman, with regard to this free consultation service, this is a collaboration between the IP Committee of the Law Society and the IPD, and we are just trying it out. It started in December last year. We intend to give it a go for 6 months. After June, then we will decide on whether we will continue the service. So far, we don't receive too many consultations. So far, 16 applications. The working group report was only issued in March this year. We believe that we can do more in terms of publicity. With regard to the 16 applications, we are arranging meetings with the SMEs and lawyers. In June, we will conduct a review to see what is the best way forward. The day after tomorrow, we'll launch the IP Manager Scheme. And we will take the opportunity to promote the free consultation service during the launching of the training courses. As for SMEs in Hong Kong, we hope that they can come forward to obtain this consultation service. Some of the applications we have received are not Hong Kong SMEs, but they are applying for IP in Hong Kong, and we will make arrangements for them to meet with the lawyers. Mr. Chong. I know that the Secretary has been looking very hard on strengthening the infrastructure of IP. And IP covers a very wide scope. Say, if a certain industry wants to submit views to the policy secretary in respect of the development of IP, how can they approach you?
Thank you very much for the question. IP trading does involve many different industries. For example, for the textiles industry, design and technology are important parts of IP. So I do welcome trade professionals to get in touch with myself or my colleagues. And I agree that we should take 1 or 2 exemplary industries in Hong Kong as an example. And for the Internet of Things, Hong Kong has its advantage as well. So these are very good examples we can trial in terms of IP trading. So, Secretary, I'll get in touch with you very soon, right? Yes, you're very much welcome. As I mentioned, textiles and clothing industry, in these industries, Hong Kong has an obvious edge. Mr. Martin Liao. Thank you, Chairman. All along, IP trading has been depending on IP intermediaries. For certain IP trades, for example, IP consolidation and insurance, Hong Kong is still lacking, and there's a general lack of awareness among the public. And this lack of awareness brings us a lot of challenges. And at the same time, Hong Kong lacks programs to nurture talents. So my question for the administration is whether or not you have specific measures to tackle issues like IP consolidation and insurance, and how would you help graduates enter the IP industries? The IPD commissioned a consultancy to conduct a survey, and Coming up, we will continue to work on this front and study the trade volume in the IP industries and see how many jobs we have available. And we would also review the manpower supply and demand in Hong Kong. So we would have corresponding measures. And under our working group, as Mr. Liao said, in terms of valuation or financing, well, when we talk about financing, valuation is very important. And valuation must be done before the transactions can go ahead. And we will establish a set of IP valuation reporting standards. And we would try to establish an objective set of guidelines to facilitate financing and insurance works. Some insurance professionals have offered us valuable opinion in this working group. I'd like to stress that IP trading is still at its infancy stage, so we have to be bold and try out new things to in order to craft a competitive edge for Hong Kong. I have a follow-up question on the corresponding measures or support measures. It's important if we are to turn Hong Kong into a premier IP trading hub. In recent years, there is a hike in the global demand for IP services in terms of volume and number of cases. We have seen increasing numbers, and at the same time, we face a number of litigations and disputes. Although the government is trying to promote Hong Kong as the Asian arbitration hub, as of yet, we have not seen any concrete measures. Will the Bureau establish specific measures or guidelines to turn Hong Kong into a hub for settling IP disputes? Thank you, Chairman. The government will try to promote Hong Kong as an IP arbitration hub in Asia, and we will also hold forums in China to educate the trades. And we want to make sure that Hong Kong becomes an important hub for resolving disputes and arbitrations. We will work with our lawyers to look into the arbitration law and see if there's any room for improvement. And this would enhance Hong Kong's position as an international IP arbitration hub. We will continue to work with the Intellectual Property Department and Department of Justice to look into this issue and promote Hong Kong into an arbitration hub. You will have specific measures right after the study. The work is ongoing. I'm not sure if the director has anything to add. Chairman, in terms of arbitration, the IPD and Department of Justice has been working with various stakeholders to use arbitration as a means to resolve IP disputes. Apart from the current facilitative model, we want to explore using an evaluative approach to mediation. We would hold an IP arbitration workshop together with the Law Society and Barrister Society of Hong Kong. We would invite a number of mediators and legal practitioners, and so far more than 300 people have already signed up. So that's about the workshop this coming Saturday. So we would provide certain training for trade practitioners to educate them on the resolving of disputes. Is my time up? So I haven't set a time limit, but perhaps you can give other members a chance to speak as well. Mr. Lo Wai Kwok, Hong Kong is an international trading hub. For normal trading activities, there are a lot of cases which involve the protection, transfer, and development of IP rights. This is not news to us. From my work in international corporations over the years, that's my impression. And personally, I believe that we have a lot of professionals who are directly or indirectly involved in IP services. When you look at solicitor firms in Hong Kong, a lot of them would include work on IP and patents. So with regards to the results of this survey, I noticed that the number of staff practicing IP work shows that this is a big trade. In the law trade, 2,700 employees are involved in IP intermediary services. And for other types of intermediary services, we have about 1,600 employees. And within the 9 industries surveyed, we have 19,000 and 15,000 people involved in IP creation and management, respectively. So from these figures, we can see that a lot of people are involved in IP services. I hope the government is committed to putting in more resources to the IP trades so that Hong Kong can be recognized in the global arena for its IP services and intermediary services. So this is good news for us. With regards to original IP services, I'm happy that the government has taken the initiative to support local registration of marks. So this is certainly worth supporting. The key is whether we can continue generation after generation. If Hong Kong does not value technologies, creativity, new knowledge and skills, then we will forever just be an intermediary, so to speak. In the past, a lot of patent and trademark services provided in Hong Kong. We have seen a lot of disputes and also opportunities with the overseas registration of marks. So I'd like the Secretary to explain to us the government's long-term policy to make sure that our good work can be brought forward for a long time to come, and how can we encourage the young people? Thank you very much for the question. As I mentioned, we have 2 main strategic areas in terms of the strategic framework. And under these 4 strategic areas, we hope to promote the IT industries. And we want to create the right atmosphere for the trade to develop. And I agree that we have a lots of practitioners in Hong Kong. And within the 17,000 practitioners you mentioned, perhaps you can refer to Annex B for the 2,700 practitioners involved in intermediary services. A lot of them are legal professionals. I hope that we don't just have intermediary services. I hope corporations only also understand the importance of IP rights. So that's why we are hopeful that the IP measures scheme can help. The creation and management of IP rights are extremely important. So apart from intermediaries, we also need to think about the creators of IP rights, and we will see more practitioners in the future, and there's certainly great room for development, and they can create a lot of high value added job opportunities. Next, Mr. Martin Liao, I'd like to follow up on the issue of arbitration. As you all know, Hong Kong is already lagging behind. When you look at Singapore, although they are not particularly successful, they have begun IP arbitration 10 years ago. And we are lagging behind Shanghai as well. As an international arbitration hub, apart from construction, other trades have not seen much success. I think the government certainly has to do more if it is to turn Hong Kong into an international IP arbitration hub. We must use a new school of thinking. 10 years ago, I already told the intellectual property development. It was headed by Stephen Shelby at that time. I mentioned the issue of IP arbitration, and today we are still talking about it. I'm sure 10 years ago we won't be talking about it anymore because we have already missed our chance, and we have to put our hands up and admit that we are losing out to our neighbors. And I'm a bit puzzled by the government's measure. No disrespect to the civil servants, but if you have to rely on civil servants alone to promote IP rights, then we can only keep our fingers crossed. Again, no disrespect to civil servants, but we do need people who have field experience, whether it's the Construction Arbitration Center or IP Arbitration Center. We must look to the competitive private market and find experienced people to do the planning. If you only rely on civil servants, I don't think it's enough. So I'd like to see if the Secretary has any concrete measures in the future and whether you would consult the trade. I hope the Secretary would think about it. Thank you very much for the question. I agree that Hong Kong has a lot of room for developing its arbitration and mediation services, and our working group member, Mr. Liu, gave us a lot of valuable comments, and we would also work with the trade to see how we can develop our arbitration services.
As for this portfolio, it is IP is the portfolio of the S4J. We will continue to work hard in this area. Yes, the Director. It is not just the work of the IPD and the DOJ. We also work with the International Arbitration Center. We meet with them, seek their views. The Hong Kong International Arbitration Center is now considering this. They have had the recommendations of the working group, and they are now considering setting up a list of arbitrators who have experience in dealing with IP trading, and in case there is any dispute, the arbitrators can be made available through this list. And in terms of rules, there may be specific rules for the arbitration of IP. We are now talking to the sector. We know that our experience may be limited. We are working with the arbitration center and also arbitration professional bodies. Thank you. I have a question in respect of paragraph 16, which is about training. It's about the courses. Who will organize the professional training courses? After the professionals have gone through these courses, what about a recognition of such qualifications, and are they related to the QF? With regard to the IP manager scheme, it is targeted at the SMEs in Hong Kong. We hope that at least in in every SME there is at least one in the management level. One in the management level will receive training in respect of IP, and we will issue certificates to those who have attended such courses. The instructors or lecturers will be lawyers and also professionals in the area of IP. We had a pilot course at the beginning of this year. Professionals will be appointed to provide such courses. Apart from this IP manager scheme, we also work with professional bodies such as the IP valuers, such as those who are responsible for financial analysis or for business valuation. We will promote the standard of valuation or principles of valuation. And we will provide some assistance to professional bodies to provide such training. In early 2015, we conducted a training course on IP. SME groups are involved in these training courses. Real-life experience is very important. The Science Park and the Cyberport have become partners of this IP manager scheme. Is the qualification linked up with QF, qualification framework? We have an open mind. This is mainly to train IP managers. If there is a need for a ranking in the QF, then we will proceed with that. Next, Suzanne Cheng. Chairman, thank you, Chairman. I have a question on arbitration and mediation. Now, the disputes are mainly arising from something registered in Hong Kong, and such registration is being disputed in the mainland. And there are similar disputes overseas. Say, Mr. Tian has a brand, owns a brand, and such a brand. In the mainland, there was a similar brand. And earlier on, there was a certain Chinese restaurant in Guangzhou, and the same name. There is a restaurant of the same name in Hong Kong, and there was litigation. I don't know whether the administration has worked with the mainland authorities to resolve such disputes. The Secretary.
糾紛係如果喺法院去舉行咧，可能需要嘅時間啦。咁
Now, because of such disputes, mediation or arbitration may be more efficient in dealing with local disputes. But as for cross-boundary disputes, we need to respect the authorities, and we are subject to certain territorial restrictions, and the registration of the trademark is subject to certain territorial restrictions, and we cannot. It is not easy to deal with cross-border disputes. And I believe that arbitration will help a lot in solving such problems. Now, Mr. So, the biggest issue is the dispute between mainland and other places. And if in Hong Kong we can do the registration and protection here, then we may have a lot of business. Will you consider getting such an opportunity? Now, they cannot resolve it in Singapore, but if they can resolve it in Hong Kong, then we'll have a lot of business. Thank you, Ms. Chang, for the question. With regard to trademarks, they are subject to territorial limitations. If it is a Hong Kong trademark, then the Hong Kong business will have to understand the protection of trademark regime in the mainland and learn how to protect its trademark. SMEs in Hong Kong should try to understand the IP laws in the mainland so that their IP rights can be protected in the mainland. As for Hong Kong trademarks getting mutual recognition in the mainland, that is not possible. The best way is to follow the trademark laws in the mainland and comply with the trademark laws in the mainland. That is the best way to protect one's interests. Mr. So, we all understand this, but the problem is still there. There are also infringing products. So we invented a ball pen, which is very special. I join a trade fair, I show it, I launch it, and sell it. But next week, there is a similar product. How can you protect my product? I have registered this in Hong Kong. It depends on which type of IP it is, whether it is a trademark or it's a patent. And that will be protected according to the law of that jurisdiction. And if there is cross-border infringement, then you can inform the C&E department and also the mainland authorities so that they can work together to combat the infringement. So you consider working with the mainland authorities to combat such infringement on the internet, or the infringement of the trademark, or the infringement of the brand. Well, we have close liaison with the mainland authorities in conducting enforcement actions. Mr. Chung Kok Ban. Well, if you want to get the job done, you need resources and money. In 2015-16, $23 million have been earmarked for promoting IP in the coming 3 years. About $7 million per year, less than $8 million. So it's just a few $100,000 per month. And you need to do training, you need to do promotion. They really don't have enough money. Why the budget is so small? Mr. So, Mr. So, are you very frugal? Well, in the past we didn't have the money. With your support, If we need to increase the budget, we'll come back and ask for your support. 5 of us here will support you, but we really don't know whether the rest will filibuster. Well, this is the start, but the resources are too small. Now the project is for training, for consultation, for promotion. You only have a few $100,000 per month. At the start, you may not too much money, but you still have 2 or 3 more years to do the job. As for promotion of IP trade, this is for promotion of IP trading under the Innovation and Technology Fund, and also Design Smart Fund, and also the Film Development Fund. There are resources available. We believe there are adequate resources to do the job. If we need to expand the program, we will come back to seek your support for more funding. Next, Ms. Ann Cheng. I agree with your project or proposal, but you only have $23 million. What can you do with such limited amount of money? I don't know whether it is the FS who gives you so little money, or you ask the SF for, or the FS for such a small sum. Did you ask for 230 and he gave you 23 million? Well, the present resources are adequate for our work, and if need be, we can seek more funding. Now, with regard to professional service, it is not just limited to the profession. It is big business. Now, we do business. We need to have the business acumen and ambition. You need to expand. Say, if you come across a foreign businessman, he asks about registration of trademark in Hong Kong. He asks about arbitration in respect of IP disputes. He asked for what strengths does Hong Kong have, and what advantages does Hong Kong have over other Singapore or Taiwan or other places. You need to give me justifications for selling the products. I need to know what can you sell in respect of Hong Kong's advantages in terms of IP trading.
Thank you, Chairman. In terms of IP trading, we have introduced the topic to members multiple times, and of course I'm very excited with it. Hong Kong has a lot of advantages in terms of financing, the quality of professional services, our legal services, arbitration services, accounting services, marketing, design, technology, and so on. Hong Kong is among the top of the world, and with backing of the vast mainland market, there is a lot of room for growth. And IP services involve a lot of aspects, including the creative industries, technologies, and so on. So we have a very important role to play. Hong Kong is rather advanced in developing IP rights or IP trading. And you can see that IP trading is a big thing in the global arena nowadays. So that's why we established a working group to gather the strengths of different experts. And that's why we came up with this very detailed report and the 28 recommendations. And with these recommended measures in place, we aim to develop Hong Kong as a premier IP trading hub. Chairman, in the paper, in paragraph 18, you said that you would monitor the developments of IP trading. Under paragraph 18, you have not given us any concrete measures. Do you have any concrete measures under paragraph 18? It has something to do with our survey. Well, 17 and 18 are referring to the same survey. In paragraph 17, perhaps we are looking at different papers. I'm looking at LC paper number 04, the Leshko brief. Recent developments. The Financial Secretary announced in the 2015-2016 budget speech that the government would set aside $23 million in the coming 3 years to roll out a series of new support measures, which include launching an IP consultation service scheme to provide free initial IP advice. Secretary, do you have this paper on hand? You mentioned the provision of a highly specialized IP intermediary services. You want to facilitate these services, right? So is there any detailed plans or concrete measures? We mentioned some measures already. For example, the intermediary services in the report. I want a timeline and what you are going to do. I've read the report myself. Do you have a timetable? Right, a timetable. Chairman, we are talking about a very wide range of intermediary services. We cannot possibly have timetables for every trade. You mentioned the facilitating the provision of highly specialized IP intermediary services. Chairman, let me give you an example. For IP valuation services, there aren't any international standards at the moment. And as such, we hope to start with the IP valuation reporting standards. If you look into the report, the set of standards includes the assumptions, the analysis, and so on. These are very important objective standards that are necessary in the evaluation work. So with these valuations, insurance work can be facilitated, and we will continue to roll out such objective standards of guidelines to promote the development of IP rights in Hong Kong. Hong Kong is not a very big economy, and we cannot ask everyone else to follow us. So as such, we have to align ourselves with other standards in the global arena. And the working group will continue to follow these steps. So we cannot have one timeline to encompass all these services. We need the right talents before we can conduct these services, right? There are no international standards in the evaluation. Now I understand why they only need $23 million. They don't have any concrete plans yet on what they are going to do. The work is ongoing, right? What Dr. Cheng expects, if she expects something to happen overnight, it's not possible. Right now, we don't have a set of international standards, and we are rather advanced with regards to IP trading. So we are something of a pioneer in establishing this platform. So 23 million is just a start. If you need more, please come back later. Mr. Martin Liao, third round, please. Please be precise, concise. I think what Chung Kwok-pan and Dr. N. Cheng undermined the productivity of our civil servants. 23 million can go a long way. Market recognition is very important if we are to develop Hong Kong into an international IP trading hub. As I know, the government has worked with various statutory bodies like the SME Service Center. The government is providing free consultation service. Some people told me that the consultation periods or the time spans are too short, and they have not explained to the users the importance of utilizing IP rights. So these services are rather redundant at the moment. And you need to educate corporates on how IP rights can be used to maximize business opportunities. I think there's certainly room for improvement in IP consultation service. So does the government have any concrete plans to improve IP consultation services for businesses? And does the Bureau have any concrete measures? The consultation service aims to help SMEs understand what IP rights are and allow them to understand how they can make use and protect IP rights in their businesses. And all these are conducive to effective IP trading. And the IP department and Hong Kong Law Society have worked together to provide these consultation services. And not all services are free. Only the initial IP consultation service is free. If further IP professional services are required, then they would need to reach out to barristers or solicitors. So not the entire package is free. With the support of the Law Society of Hong Kong, we are able to provide free initial IP consultation. As far as I know, the government will provide free initial consultation, but if you need to have your trademark registered, you need to turn to professionals, right? You have to pay. If we have no further questions, I'd like to thank the Secretary for being here today. So let's move on to the next item. The application of the protocol relating to the Madrid Agreement concerning the international registration of marks to the Hong Kong Special Administrative Region. So, Secretary, please stay for this item. The Deputy Director is also here. Thank you very much. Deputy Director, Assistant Director rather, for this item, we have the Principal Assistant Secretary, Ms. Fabia Tam, Deputy Director of Intellectual Property, Ms. Lee Sao Kong, and Assistant Director of Intellectual Property, Ms. Joyce Poon. Thank you very much. the government has provided to us 2 sets of paper, including CB brackets 1 831/14215 as well as CB brackets 1 831/14215 06. Shall we invite the PAS to walk us through this paper? And on the 18th of November last year, on the Madrid agreement, we launched a 3-month consultation exercise on the proposed application of the protocol, and we briefed members on the recommendation, and the public consultation ended in February this year. And having consolidated the comments, we would like to brief members on the results. Perhaps I would explain the Madrid protocol. Trademark owners, trademarks are granted in each jurisdiction separately. If trademark owners wish to apply for registration for their businesses, they would need to apply separately in each jurisdiction. The Madrid Protocol is an international agreement which seeks to facilitate the registration and management of trademarks in different jurisdictions. Under the protocol, a trademark owner may apply for registration in one or more countries or territories by filing a single application and paying one set of fees. And they can also manage their trademark portfolios later through a single procedural step with the World Intellectual Property Organization, or WIPO. The protocol was first adopted in 1989, and it currently does not apply in Hong Kong. In order to enhance Hong Kong as an IP trading hub, we feel that the application of the Madrid Protocol in Hong Kong would be beneficial. According to a consultation brief issued in November last year, we included the pros and cons of applying the protocol in Hong Kong. And during the consultation period, we have consulted the main stakeholders, including the trade practitioners, and we have held briefings. During the consultation period, we received 21 submissions, mainly from trade associations, chambers of commerce, and professional bodies. In general, the majority of the respondents support the application of the Madrid Protocol to Hong Kong. They agree that the protocol would benefit businesses in Hong Kong, and the one-stop registration and management services would facilitate the registration and management of trademarks, and the introduction of the Madrid Protocol would help local businesses expand overseas, and the Madrid Protocol can also help establish Hong Kong as an intellectual property trading hub. And and some respondents, mainly from the trademark profession, also express reservations. They do not feel that it's efficient, and they might jeopardize the Hong Kong, the local practitioners.
We've already provided a summary of the views in the annexes and also in paragraphs 6 and 7 for reference of the panel. We are now considering the views collected with a view to planning the way forward. We'll maintain communication with the stakeholders. We welcome your questions. Thank you. Ms. Ann Cheng. Concerning the Madrid Protocol, has our country signed the protocol? Is China a member? If Hong Kong joins the Madrid Protocol, then the trademarks registered in Hong Kong will be recognized by the mainland. Is it the case? No, not at all, according to my understanding. Just now, the Secretary has raised the same point. Trademark is subject to territorial limitation. If you want to get protection of a certain jurisdiction, you must register with that jurisdiction. There is no mutual recognition of trademarks with the mainland. Well, I've stepped on a landmine in this regard. Can you be more specific? So what's the benefit of the Madrid Protocol? Chairman, if I may add, the Madrid Protocol is an international agreement. Hong Kong and the mainland is an arrangement being regarded as a domestic arrangement, and therefore the Madrid Protocol doesn't apply between the relationship of Hong Kong and the mainland. But if it is in relation between Hong Kong and other countries, then it will prevail. This is a more speedy way of applying for trademark registration. Traditional trademark registration is limited to jurisdictions. If I want to get protection in 10 jurisdictions, then I will have to go to each and every one of the 10 jurisdictions for trademark registration. But under the Madrid Protocol, the applicant can pay a set of fees and make a single application and protect the trademark in the several countries or territories. Now, procedural-wise, it is more speedy. When different countries have received the application, individual trademark authorities will consider the registration according to the local law. In terms of the application process, it is more convenient. The business sector welcomes this because when a registration is successful, then future renewals and other procedures can be done by just going through a simpler step. It's just a one-step arrangement instead of going through various jurisdictions for renewal and for managing of the trademarks. Now, after we've joined the Madrid Protocol, will that affect Hong Kong adversely? In the previous discussion item, we discussed the ways and means of enhancing IP trading and also promotion of IP trading in Hong Kong, getting more business for Hong Kong. With the application of Madrid Protocol to Hong Kong, will that reduce the business in Hong Kong? Well, Chairman, you better not answer the question on their behalf. I thank Ms. Cheng for the question. If the Madrid Protocol is applicable to Hong Kong, local SMEs can go into overseas markets by registration to protect their trademarks. This is more efficient. And we can also attract overseas businesses to come to Hong Kong. In the past, they might not have considered protecting their trademarks in Hong Kong. Through the Madrid Protocol, they may discover that Hong Kong is a place where the Madrid Protocol applies, and they may start doing their businesses in Hong Kong. That may also enhance the popularity of registration of trademarks in Hong Kong. They may discover the strengths of our systems. They may discover the quality service of our legal professionals. This will enhance the business of the legal profession in the area of trademark representative service. this is about IP registration. This is about trademark registration. It's not about IP at large. Mr. Low-I-Kok, if my understanding is correct, if the Madrid Protocol is applied to Hong Kong, then a trademark registered in Hong Kong will also be recognized by the signatories of the Madrid Protocols. Madrid Protocol, is it the case or not? Strictly speaking, there is no automatic mutual recognition. A Hong Kong applicant can go to the Hong Kong registry and register its trademark and make an application. And basing on this registration through the Madrid Protocol or through the Madrid Protocol system, he may designate the registration of the trademark in certain overseas countries. The overseas, the application form is filled in with one language, and there is only one set of form. It saves the translation cost. It is more speedy. But when it comes to when the application form goes to the overseas country, the authority will look at the trademark and whether it's in line with local law. If they do not object, after a certain period of time, then the trademark will be also recognized in that place. In other words, Hong Kong is not a signatory. Hong Kong is not a signatory of the Madrid Protocol because the Madrid Protocol is an international agreement between countries, and China is the signatory. And we propose to apply the Madrid Protocol to Hong Kong with the help of the CPG. In the future, Hong Kong can enjoy the benefits of the Madrid system. Now, Chairman, let me put the question in a simple way. In the mainland, there is an applicant who has successfully registered a trademark. The other signatories of the Madrid Protocol will have to recognize that trademark. Is it the case? No? Or yes? No, not at all. Not either. The applicant in the mainland can work through the Madrid system and designate overseas countries such as United States or European countries. I find it strange.
唔係，呢個俾佢解釋。
接觸嘅比較少，我又喐緊。
因為如果你呢個係
其實馬德里協定
The Madrid Protocol will simplify the registration procedures. Say I have registered in the mainland, then the 94 signatories of the Madrid Protocol will use a simpler way. You don't need to do the registration. You don't need to translate the documents. You'll be allowed to go through the process. But you just apply through one country. If you don't go there and register, your trademark will not be recognized. You have to register with that particular country. When you make an application, you have to designate which country, from which country you want to get the trademark protection. It is not an automatic registration. It is not a multilateral mutual recognition system. No, not at all. When I look at the comments, many say that there will be the benefits, but that is a misunderstanding. It is not mutual recognition. It is not one registration with 93 protection in 93 countries. No, not at all. Let me clarify this. During the consultation period, we have briefed the stakeholders. They understand the operation of the mechanism. There are two technical issues. First, Hong Kong is not a signatory of the Madrid Protocol. When an applicant applies for registration, say, for registration in the mainland, will that undermine the authority of the trademark registry in Hong Kong? The standards for vetting the application are different between Hong Kong and the mainland. Now, after joining the protocol, if a trademark is an effective trademark registered in Hong Kong, then will the same trademark will have to go through the recognition of the trademark registry in Hong Kong and obtain the registration in Hong Kong. The second question is on enforcement. After registration, the Hong Kong court will enforce the registration, will enforce the trademark rights if there is any dispute in Hong Kong and the Hong Kong law prevails. Whether a trademark can be enforced in Hong Kong is different from those in the mainland and other 93 countries. Say, for example, for non-use provisions, they may be different from country to country. In terms of enforcement, will that be enforced according to Hong Kong law by Hong Kong courts? I thank Mr. Liao for the question. On the first question, according to the Madrid Protocol, the procedures for application will be simplified, but the trademark vetting, say for example, whether an application is a trademark is protected or not by the local jurisdiction, it will be vetted according to the local law of this said jurisdiction. So there will be substantive vetting if an application is brought before the trademark registry in Hong Kong. As for the second question, when an international trademark is being traded in Hong Kong and if enforcement is necessary, then it will be enforced according to the local law.
Mr. Lo Wai Kwok, Chairman, I noticed that in the views of the submissions of some respondents, for example, the Hong Kong Law Society, they are of the opinion that if the Madrid Protocol is applied to Hong Kong, the number of overseas trademarks registering in Hong Kong will decrease, and the number of local trademarks registrations would drop, and as such, the trade will be affected. How would you elaborate on this view? I don't really understand this stance. Some people feel that the application of this protocol has a negative impact on Hong Kong's trade. How would you understand that view? There might be some concerns with the trade, and right now, overseas trademarks who like to come to Hong Kong might currently be done through certain local agents, but with the application of the Madrid Protocol, the applicant can make use of the Madrid system, and they can simply submit. They can simply apply overseas for registration in Hong Kong. They no longer have to rely on trademark agents in Hong Kong. We are still looking into their views and consolidating their submissions, and we are doing some research as well. The situation might not be so bad, and we can share certain research results. In the last few years, we've seen an increasing trend in the number of trademark registrations. Between 2012 to 2014, the increase was about 39%. The average increase was about 8.5% per year. So in terms of trademark registration, we have seen an increase. The Madrid Agreement merely provides an extra option for trademark applicants when they apply for trademark protection in Hong Kong. It's not the only or exclusive way for applying for a trademark. We believe that this agreement cannot replace local registrations completely. And in terms of percentages, in the past few years, the average number of local trademark registrations by Hong Kong firms consists of 30% of the total, and the ratio of mainland applicants is around 20%, and together they make up 60% of the total number of trademark registrations. Once the Madrid Agreement is in force, we believe that there would not be drastic drops in number of applications. When we look at overseas examples, in other jurisdictions, we have not seen across-the-board drops in the number of local registrations after adopting the Madrid Agreement. In some cases, there have been increases, for example, mainland China, the United States, and Korea. In some jurisdictions, there have been decreases in local registrations, but the number of international registrations have increased. And as a result, the local agents can also benefit. For example, they can provide IP search services, trademark protection services, or related legal services. These are all high value added services. And some respondents represent small, medium-sized solicitor firms. They feel that if the Madrid Agreement is applied to Hong Kong, they can provide trademark agency services at competitive prices, and this is beneficial to Hong Kong's SMEs in the long run. So these are some preliminary information to share with all of you. Chairman, I have another question. If a Hong Kong business wishes to register for a trademark in another country, if their target market are one of the contracting parties in the Madrid Agreement, they can conduct the registration under this agreement, right? So this has nothing to do with whether the Madrid Agreement is applicable to Hong Kong, right? Under the Madrid Agreement, the trademark owner must satisfy one of the three conditions. It must be a national in one of the contracting parties, or its business must be registered in that particular country, or it has the right of abode in the specific country. So this is in accordance with the common law. They must have a physical venue of operation in that country, for example, a factory, an office, and so on. In some cases, as you said, if a Hong Kong business has a subsidiary in the UK, or if it has an office or factory there, then they can apply for trademark registration there. I have a follow-up question. Since China is one of the contracting parties under the agreement, if the applicant is based in Hong Kong, so China does not include Hong Kong, right? Even though it is a contracting party. I'm a bit puzzled because Hong Kong is part of China. Hong Kong is a special administrative region, but it's still part of China. So why does this agreement not apply to Hong Kong? Why can you explain the connection? I'll try to clarify that. China is one of the contracting parties under the agreement when it's adopted the Madrid Agreement during the handover of Hong Kong to China. China made a declaration that the Madrid Agreement would not extend to Hong Kong. It was a declaration submitted separately to the United Nations. So adjustments have to be made, right? Chairman, with the application of the Madrid Agreement to Hong Kong, does it mean that the earlier declaration, which excluded Hong Kong, would be revised so that it now includes Hong Kong? If the agreement is to be applicable to Hong Kong, the relevant declaration must be amended. But with regard to the specific wording used, we have to sit down with the central government and work it out later. If the Madrid Agreement is to be applicable to Hong Kong, the purpose is for Hong Kong to enjoy the procedural convenience under the agreement. So, in other words, Hong Kong would be another contracting party, right? China is a contracting party because only countries can be contracting parties. Of course, China signed the agreement, but if you are to include Hong Kong, Hong Kong can enjoy the privileges and powers of a contracting party. Yes, in effect, you're right. Dr. N. Cheng. Thank you, Chairman. As far as I know, we are proposing application of the Madrid Agreement to Hong Kong. After we wrap up studies in Hong Kong, are we going to bring the proposal to the central government and ask them to request the Madrid Agreement organizers to accept Hong Kong as a member? Yes. Have you held discussions with Beijing? We will continue to liaise with the central government. So as we understand, they support the proposal in principle. And however, we have just wrapped up public consultation, so we have to consider the comments and submissions as well. The specific arrangements of the agreement would involve the international IP organization, so we will iron out the details with the central government. After the handover, why weren't Hong Kong included into the Madrid Agreement? Did Hong Kong request to be taken out of the Madrid Agreement, or was the central government unhappy about Hong Kong and as such they excluded us from the agreement? She wasn't born at that time, I guess. Well, of course, that's not true. When we look at the Madrid Agreement, during the handover, I wasn't involved in the work yet, so I have no personal experience to share. The Madrid Agreement was only effective after 1996. And the contracting parties, there were only a few contracting parties at that time. As you know, more than 200 multilateral international agreements apply to Hong Kong. For a lot of these treaties, they never had a lot of contracting parties at the beginning. So after quite some time, it was agreed that it would apply to Hong Kong, and such it would be introduced. Chairman, by joining another international treaty, I think this is something Hong Kong has to do. It would be great if we can join. But we are seeing a lot of embarrassing situations for the ASEAN agreement. I've always lobbied to the government that we have to join ASEAN, and the member countries enjoy a lot of concessionary arrangements. If all the provinces in China can enjoy the convenience or concessions, but yet Hong Kong is excluded. So it's a strange situation. I hope we can join sooner than later. Of course, this has nothing to do with the intellectual property development. That's just my opinion. And having heard the discussion so far, I don't really have a good idea of the pros and cons of this agreement. But if we have the chance to join another international treaty, it's a good thing. You can try to register your business, once the agreement is in force. So, in the gist, this agreement brings convenience to businesses who wish to register in Hong Kong, right? They only have to use a single language and pay a set of fees, and they only have to pay a single set of fees to conduct the registration. But somewhat the local trademark practitioners might be jeopardized. Hopefully, that will not happen.
Some countries have been slightly affected, though not a substantial amount of business has gone. Since there is no much adverse impact, why not join it? I support it. Well, I don't want to say where I support. And we are not asked to say whether we support or not. All right, we finish with the 2 items on the agenda. There is nothing on the AOB. So thank you very much. The meeting is adjourned.